So let's take a minute. What I want to do is take kind of inventory for a moment about what we've accomplished so far this semester, okay? And I think it's probably more than you all realize. So one of the things that's often said about, or when you come to law school, and I probably mentioned this before, people say law school doesn't teach you the law. It teaches you how to think like a lawyer. But the difficulty with that is no one seems to ever say what that actually means. Perhaps no one has really thought past the maxim of that. And in fact, in some ways, it doesn't seem very true at all. When you go to your torts class, for example, your civil procedure class or your contracts class, I mean, what are you doing in those classes every single day? You're learning the law, right? You're assigned cases, you're reading the cases, you're at least asked to participate in terms of your comprehension of those cases. But it's also true that when it comes time to take your final exam, it's not going to be as simple as that, right? It wouldn't be a very good law school final exam if question one was, here's the name of a case, tell me what the holding of that case was. Right? Now here's the next case that you read, tell me what the court decided in that case. Right? That would be kind of just a test or an exercise of memorization. What's really happening in your other classes is you're learning the law in order to get to the other side of that and be able to think like a lawyer through the process of engaging these cases and learning the law. In fact, when you take your final exam, the questions are going to test your ability to use the cases much more than your ability to just simply know or recall the cases. It's assumed that you know the cases. The question is, when your professor gives you, say, an essay question, or maybe even a multiple choice question, it'll often be a hypothetical situation that is not a one-to-one connection to any of the single cases, but it'll implicate a variety of cases and then ask you to consider in some way or another how those cases kind of work together and how you can bring them to bear on this new hypothetical situation. So in a quote-unquote doctrinal course, what you're doing is you're learning the law in order to learn how to think like a lawyer, right? What we're doing here is trying to get to the same goal, thinking like a lawyer, but we're doing it in a little bit of a different way. What we're doing is we're not learning very many cases and not learning very much law at all. But what we are definitely doing is we're engaging that material much more deeply than you do at least at this point in the semester in your other classes. Right? So take the closed memo assignment. You're only learning 4 cases, even though those cases rely on other cases. So by implication, maybe you're learning 10 cases or something that someone could tell me about in this class. But it's not a lot. But what we're doing is we're going through the process of struggling to see how those cases work together and then to be able to articulate that in written form. And that, in a lot of ways, is a more direct approach to thinking like a lawyer, right? In fact, there's a lot of social scientific research, like in the areas of education, for example, where people have studied how do students best learn, right? So there's one study in particular, which is a group of undergraduate students, and they were broken into 3 different groups. One group, they just received passive lecture material. So there was a professor just lecturing, everybody just sat there and listened, right? At the end, they were given a test on the material, right? That's group A. Group B, same thing, but the professor called on the students and forced them to kind of speak and engage the material, right? Kind of talk their way through it, kind of like Socratic method or something like that. So that's group B, given the same exam at the end. Group C, kind of same thing, except for the students had to do written essays or something like that trying to engage the work in written form and articulate some of these ideas. Same exam at the end, the students who engaged with the ideas in written form were forced to articulate it and kind of think, well, what am I trying to do here more definitely, did much better on the exam than the other students, right? And so the conclusion that I get from that is that this process of knowing and then being able to articulate what you know, that struggle is what is most beneficial to learning how to think, right? And there's a lot of people who have written on this and made these, it's not my observation. So it's often true that later, maybe after the first summer often, but maybe after a person graduates and is in practice, you'll have students come back and say, I now realize that legal practice was the most important class I took in law school, right? Now, what does it mean when they say now? What's the implication of that? They didn't, right? So, and I'm not asking any of you to agree with that, and none of those people would have agreed with it really so much at the time. But the truth is that the practice of law is done most of the time in written form, right? It's not being called on. It's often not some fresh hypothetical that implicates all these constitutional law issues. But sometimes it does, and sometimes it does more often than people realize. So here we've been doing kind of this, dorky assignment of students wearing pins, the turnip pin or the pork chop pin. But through the process of trying to engage this, we've been looking at some really important cases, right? So if I were to try to kind of think about how we've gone about approaching it, and I've done this before, what are the big kind of underlying themes that kind of feed into all of this? Well, we know one of them is the First Amendment. And the other kind of thing that feeds into all of this is what sometimes the cases call the special characteristics of the school environment, right? The fact that we're in the classroom kind of seems to make things different. So we've got that, and that's kind of the underlying everything. But what we've been doing by reading the cases and thinking about them and describing them and then thinking about them holistically to applying them to a situation, if we started to develop kind of this structure where we have Tinker, which is our general or our default rule, and then we've been looking at ways in which the Supreme Court has carved out a variety of exceptions to Tinker. And then we've been looking at examples of where the different circuits are reaching conclusions extending Tinker to off-campus speech to see how it plays out in those particular circumstances, right? We had one case out of the Third Circuit. We had one case out of the Fifth Circuit. Both are beholden to the U.S. Supreme Court, but not each other. So it is interesting to kind of think, well, what if you had taken the JS case and put it in the Fifth Circuit? Would the outcome have been the same? Or if you took the Bell case and put it in the Third Circuit, whether the outcome would be the same? Maybe the answer is yes. There is a way to reconcile those cases, right? But you never quite know. And in fact, these types of cases, we've only looked at a few of them, the most important ones. These types of things are happening all the time. I've had friends, for example, who had their kid was suspended. Someone I used to work with, her son was suspended from school for a text message he sent to one of his other friends outside of school. And he got suspended, and I knew these cases, and I told her, I said, I think you should fight this, right? I think they didn't have the authority to suspend your student based on my knowledge of the cases. Ultimately, she did what most parents do and most students do, is say, we're going to take it on the chin. It's only a few days, and we don't want to go through all the trouble of a court case or additional hearings or stuff like that. He did something that he probably knew he shouldn't have done. He got in trouble. He'll be back in 3 days, no big deal. Okay, that's what normally happens. But knowing, the law, in being a lawyer, you're going to have people that come to you with all sorts of different problems, right? You're going to talk to someone on Thursday, a fake two people, split personality, that has some problems, right? And they're going to come to you looking for answers or looking for analysis. And that's a difficult position to be in. One of the things we're really good at as just thinking people is having an intuitive sense of when something wrong has happened, right? We've spent our whole lives kind of nurturing a sense of fairness, a sense of right and wrong, these types of ideas. But we haven't been thinking like a lawyer. So you'll have people that come to you, like let's say a student, comes to you suspended. You might be able to feel like, yeah, it seems like something wrong happened here, right? And, but you have to be able to articulate that in legal terms and in legal analysis. And that's the real big shift that you're having to make right now. Because you can't just show up in court and say what happened was unfair, therefore we should win. In fact, fairness type argument is often one of the weakest arguments you could ever make in a legal proceeding, right? It's often called an argument in equity rather than an argument in the law, for example. Even though a lot of the law and a lot of the legal analysis exists for the purpose of getting at ideas of fairness, right? But we have to articulate it and couch it in legal terms. And that's what you're going to have to do as law students, and that's what you're going to have to do as a lawyer. So what we've done is we've taken a situation, and now we're trying to kind of reword it, the whole thing, in terms of legal analysis, even if it ultimately is about fairness, right? So we're identifying the relevant legal standard. We're reading other important cases that maybe have created exceptions. We're asking questions about whether the exceptions apply or we use the default rule. And then we're looking at other cases that have applied that rule and see, well, what are the important considerations that those courts weighed, right? And then if I applied those same considerations to our case, how does that affect the outcome? And now we've created kind of this series of filters through which we're putting all of our information. And that starts to be legal analysis, right? How many of your opinions, for example, that you read in your case ever even used the word fairness, ever used the words right or wrong? Maybe none. Maybe there's a couple of places, I don't know. But it wasn't part of the holding. It wasn't core to the analysis, even though that's what all of those cases are ultimately about. And so we have a right? The framers said there's something that we really, really value. We're going to put it in the Constitution. And ever since, we're trying to kind of figure out, well, what do we do with that right? And we have to always do it in legal terms. Okay, I said that. What I'm going to tell you next is that through this silly assignment, we've built a legal structure, and we've taken new information and put it through that structure and done legal analysis. You could approach any question of law, any area of the law, any type of thing, even if you had no knowledge of it, through this same methodology. Let's first identify what we think might be wrong. Let's try to find the relevant legal standard. Let's develop our research. Let's ask questions about how it all fits together. And then let's bring it to bear on the new situation. So I could give you, this was a First Amendment case, I could give you a Second Amendment case. Your approach to it would be the same. What's the governing standard? What are the important cases? What can we learn from that? What are the considerations? Okay, let's apply it to our case. I could give you a bankruptcy case, right? I don't know anything about bankruptcy law, but I could write a really good memo on bankruptcy law because I know how to go about learning about something. You don't have to know everything, you just have to know what's going on in your little structure, your little world of the law for purposes of your thing. So what I'm saying is what this whole assignment is thinking like a lawyer. And if you can just remember what you did for that case, you can do it again for the new case. You get even a little bit better at it. And then you can do it for any case that would ever walk in the door, right? It's okay to say, I have no idea, but I know how to figure it out. And I can give you an answer, right? And I spend, even in my area, federal criminal law, where I do know all the cases, there are a lot of questions that are kind of unanswered, right? And, but I know how to figure out the answer. And that takes a lot of experience, and you get better at it over time. But I want you to know that you should have the confidence of just doing this one assignment, that you know how to think like a lawyer and then articulate everything. Those are also two very separate things. It's not enough to just know everything. You have to be able to put it into words. And that's not just like spelling and grammar. That's a whole different part of the struggle, is being able to put it down in an organized way. I mean, our guiding principle here is the CREAC structure. That helps a lot. That's also something that just comes with practice, right? One of my best friends is arguing at the U.S. Supreme Court in November. And I've been helping him prepare for the case. And he, right now, in his mind, has more knowledge of this area of the law than anyone else, period, in the United States, right? But when we did our first moot, where we had him present the argument and we were acting as the different judges asking him questions, and that was a week ago, very rough, right? Took a long time to get to the point. There was some explaining. There were some pivots that should have been go one way, but he was going the other way. And so now he's in that process of articulation, of being able to explain it, to be able to do it confidently in an organized way. And so that's what we're doing. So I just want you to know, to take inventory for a minute, to say that you should be very proud of the work that you've done in this class. And you can carry this with you, and you can tackle even the most difficult or intimidating cases. I mean, you could take every single case that's pending at the U.S. Supreme Court right now, and you can break it down to something probably about like that, quite simple. The questions are often simple word questions or line drawing questions, or how to extend a rule to a slightly new situation. Right? I think, I've often thought, well, I'll write an article about this one day, that you can take probably every legal question in a Supreme Court term, so they hear about 80 cases. And if you were to really get to the root of what the structure of that question is, it's these very simple things, and there's probably about 4 or 5 different structures that you ever would even confront in a whole Supreme Court term. So the way we have to think is not that hard, but it's getting there that's really hard. It takes a lot of work. Okay, so I want to talk about research a little bit. I know you all are doing these research workshops, and you're learning all about legal research. You probably know more than I do at this point. So let's take a step back. Let's pretend like we don't know about Tinker or any of these cases. Okay? And you have someone come into your door I've got this wonderful son. He would never do anything wrong. His name is Linus Stone. And he got suspended, and it's totally not his fault. And what should we do, right? You don't know the cases. How would you go about trying to create that structure if I hadn't given you those cases?
What did he do in the first place?
Yeah, I mean, what would you do? Someone comes to you right now and says, I've got a problem, and you feel like, yeah, it seems like something wrong happened, but I don't know. I'll have to research it. How do you start your research, or how do you go about it? What would be just kind of a path of least, what if I asked you, what would most lawyers do that haven't taken the writing workshops, or the research workshops?
Google.
Google.
Case law.
Okay, we're gonna go every one of these directions. So let's start with Lexis or Westlaw. We'll come to that. We'll come to Google. Case law, where's all the case law located? Let's say you've got the subscription, you've got access. Okay, what do you do on, let's go to Lexis. What do you do on Lexis?
Oh, what state are we? We had to like go to like the jurisdictions, right? To see like which cases are.
Well, I'm just asking you, how do we even know where to start?
Go with search terms.
Okay, search terms. What would be, you don't know anything, what would be a search term? What would be some search terms that you would try? Yeah, student speech case.
First Amendment.
First Amendment. Hold on, let me put this up.
School suspension.
First Amendment and maybe student and suspended, right? So we're throwing out everything we learned in our research workshops, and we're just going straight to just putting in key terms, see what happens. Let's see what does happen. It looks like we've got some sort of Eastern District of Pennsylvania case. I at least want to find like a circuit case. So our second case here is a case out of the Ninth Circuit. Don't know anything about this area of law, but when I look here at just the brief excerpt, it even it shows us that we're moving in the right direction. Applying Tinker, we further hold that the plaintiff's petition and complaints, etc. So I'm going to click on that Ninth Circuit case. Hopefully it'll bring me down to that part. So it says, contrary to the district court, we hold that Tinker's standard for determining whether the First Amendment protects student speech does not include blah, 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 which probably isn't really relevant to my case. But then it says applying Tinker. So initially, I'm starting to think, well, what's going on with this Tinker case? Applying Tinker makes me think, well, maybe that could be the governing rule or legal principle. So I can simply click on that, and then I'm here, whether I know it or not, kind of at the root of the trunk of the tree, right, through keyword searches. So I know keyword searches are sometimes discouraged in legal research, and it is true that it can lead you down like wild goose chase, rabbit holes type thing. But here, pretty quickly, we were able to scan a couple of cases, at least the First Circuit case I came across. It led me to Tinker. Now I have this Tinker case. What's an observation I can make about how much weight or how much confidence I could have in this particular opinion?
Supreme Court.
Supreme Court, we're off to a good start, right? We don't see any like red stop signs or anything. That helps. Another thing I want you to look for is up here at the top. When we're trying to kind of build the trunk of the tree, typically you go chronologically, right? The big general rule is going to be at the bottom. It might get refined, or they might carve out exceptions as you go up. Look how many cases here have cited Tinker. That's all the future cases that are referring back to Tinker, right? Citing decisions, 2,750. That's a really kind of big number. So I'm starting to feel like this might be one of the most important cases. Of course, what I'm also going to do is I'm going to go look at the cases that Tinker is relying on. Because I might have ended up in the middle of the trunk of the tree, and there might be the big case might be below it. So I have to go look at the cases that it's relying on. Of course, when I ultimately would do that, I would say, yeah, those are really important. There's a lot of general principles there, but Tinker really is the bottom of the trunk of the tree. So you need to really think about doing legal research in the sense of, if we put any area of the law and we took all the cases out of Lexis or Westlaw from that area, and each one was like a dot in the sky, like a star in the sky, right? And then you start drawing lines between them to show the connections or relationships or reliances between them. They all kind of flow down to the main line of cases. So it's kind of like you go to that creek in your backyard and you follow it, and it goes to the river, which goes to the big river, which goes to the ocean, and everything kind of ultimately leads out to the ocean. That's what legal research is doing a lot of, right? It's like you take any of your favorite bands, and there was that first song that you heard by them, right? And then you go out and you buy the album, and then you listen to their other albums. So for me, like my favorite singer is Bob Dylan. And so I buy, in 1994, I buy the Forrest Gump soundtrack, which has all these songs from the 60s, right? And one of them is Blowing in the Wind, and I hear that, and I think, wow, this is really something that appeals to me. Not everyone has to agree with that. And so I see, oh, I really like the song. Who is this? Well, I want to go see what album Blowing in the Wind is on. So I go buy the Freewheelin' Bob Dylan, right, his second album. And then I think, wow, I really like all of these songs. I want to listen to the albums before and after that. And whether you start early in the career or later, it's all going to funnel into his great 3 albums in the 1960s, right? Bringing It All Back Home, Highway 61 Revisited, and Blonde on Blonde. And you can start earlier, you can start later, but it all leads up to that main kind of trunk of the tree, right? And it works for this or anything else. So this is one way of doing it. And then when I click on the cases that have cited Tinker, we'll see probably first some Supreme Court cases. And then, this is kind of a big mess now when I start to look at how this is working. A lot of these are religious liberty cases that wouldn't apply to school speech, for example. So I may need to change how I'm kind of doing my display settings, whether I'm doing it based on relevance or the amount of discussion or these sorts of things, right? So I don't know what I have right now, court highest and lowest. If I went discussion high to low, maybe I would have better luck here. It appears that I do, right? What are the cases that are most engaging with discussions of Tinker? Well, Morse versus Frederick, number 1. This other case that I don't really know, but Hazelwood we're familiar with, Frazier we're familiar with. And you'll see if you did more research that there's a newer case. The Supreme Court has taken a 5th case on student speech just a couple of years ago and explicitly applied Tinker to off-campus speech. It was you may have read about it in the newspaper. It was a person who tried out for the cheerleading squad, was not accepted, and then said a bunch of bad words about the school off campus, right? And I believe the Supreme Court sided with the student in that case. But what was most notable is that we now are very confident that the Third Circuit was correct and that the Fifth Circuit was correct, that the Tinker standard does apply to off-campus speech, right? So this is one way of going about it. If you're in your research workshops, what's maybe a better way that they would tell you to go about doing this?
They wanted us to go to secondary sources first.
Okay, so let's see what we can do going that direction. So if I were to click on sources here, okay. And so these are going to be a lot of our secondary sources. You've kind of have to have some base knowledge to know what sources are helpful for you. Some are way too specific, some are too narrow. One of the ones that's good if you're dealing with a constitutional kind of big picture issue is an encyclopedia-style source called American Jurisprudence. Have you talked about that at all in your research? There's a few different things that sound like that. There's American Law Reports, American Jurisprudence. Texas Jurisprudence is a Texas-specific. But this is a good kind of middle-of-the-road secondary source. So we're going to type American Jurisprudence. And thank goodness it's on Lexis. I think it's also on Westlaw. And what I want to do now, because I don't really know my search terms necessarily, is I'm going to browse American Jurisprudence to see if I can find kind of a chapter that's helpful for me. It's in alphabetical order. And so what would be a word I'm looking for here? So speech, any other ideas? Schools? Someone say that. You've kind of got to sift through a lot of this, but I say schools because it's an S before speech. And we actually did this in the earlier class. The first person said schools. So fortunately for us, schools is here. There's probably a lot of concerns with schools. Now we have all these sub things to look at. Probably no, probably no, probably no. But we can get down here to number 8 is students. Well, that feels promising for us. And then we have a variety of different things. Right to attend, transportation. Let's do school regulation of students. It doesn't necessarily have to be punishment, but I bet that leads us back to where we want to go anyway. And then subsection 3, students' right to freedom and expression and personal autonomy. Personal appearance, that's probably dress code type stuff. So let's go with free speech rights and, in general, students' right to free speech in school. Okay? Now, I can read through this, but I'm just going to take a quick glance at the footnotes to see how confident we can feel in this type of thing as a source. Footnote 3 cites Tinker. Knowing what I know, that's an important case. Footnote 6 cites Morse. Footnote 7 cites Hazelwood. So it seems, just to evaluate this, this would be also a really kind of good way to get a lot of information quickly, something like this. So to read these paragraphs and then look through those footnotes. So that's another way of doing it. Yeah?
Is this what you did with ours?
No, it's not. It's a long story about how I got into student speech, but there's a much longer story to it. I'll tell you, it's not like a secret, but it was a moot court competition where I was brief writer and advocate, and it dealt with some of these student speech questions. And so I had to write a big appellate brief engaging these cases and a lot more, and then I had to argue it and travel, across the country to do it against other schools. So just going through that process, we talked about the struggle of articulation and knowing and all that. I had to do that like in a really serious way. So I just kind of always stayed interested, and anytime a school speech case comes up in the news or something, I'm just like interested because I kind of know the legal framework for it, and so it always kind of feels relevant. So I didn't create it just out of nothing for your purposes. It's kind of an area of the law I've always been interested in. So, okay, so this is good. What's the other way? You mentioned Google. Let's talk about, so let's get outside of Lexis and Westlaw. What would be one place, one type of source that we wouldn't rely on, we wouldn't cite, but could be a helpful source to get information?
Wikipedia.
So Wikipedia, right? The forbidden source. Why don't we rely or cite
I could go
Wikipedia?
change it right now. I could go add whatever I wanted to Wikipedia.
Did you update Tinker on Wikipedia?
That's right.
I might.
So the reason we can't rely on Wikipedia as a source is that anyone can edit Wikipedia, right? So it's not fundamentally reliable. What's also true is that so long as it's not a hot button issue where people have really strong opinions necessarily, Wikipedia is almost 100% accurate. Okay? In fact, there have been studies on it comparing it to Encyclopedia Britannica, and Wikipedia is more accurate on scientific articles than Britannica is, right? And more thorough. So I'm not saying Wikipedia is the end all, but I'm saying if you've only got 10 minutes and you want to get a lot of information really quickly that you're later going to follow up on by reading the cases, well, let's find out. So I just searched School Speech Wiki, and look what we come across here. In 2 paragraphs, we've got Tinker, we've got Frazier, we've got Hazelwood, Morse, and then this is the new Supreme Court case dealing with the cheerleader. So we've got all 5 Supreme Court cases in one place almost immediately. And then we have a little summary of each one, and then some additional analysis and references to some of the circuit courts as well, right? So all I mean to say here is who would deny the value of a source like this? Not to rely on it, not to believe everything that it says. But if I'm just trying to figure out what are the most important cases in an area of the law, so I can then go read those cases, this, at least in this area of the law, would be a really, really helpful resource. I'm not really going to even read these summaries or these individual pages on them. I'm just going to now have my little list of cases that I can go pull up on Lexis or Westlaw and read and make my own decision about what they actually say. So there's more than one way to get at kind of figuring out what are the main cases, and then how do I structure the legal analysis. But even the ways that are discouraged, you can get there. And in some areas of law, they could be better. Now, if we're dealing with a Texas-specific legal question like we will for the open memo, Wikipedia is not going to really do much for us, right? But Texas jurisprudence, one of those secondary sources, is probably really helpful. Keyword searches could be really helpful. So I just want you to keep all options open, and ultimately you'll have to figure out what works best for you. And part of our job is just to let you know what are the different tools that are available, so later on you at least know that they exist and have some sense of when they can be most useful.